Hello, welcome or welcome back as the case may be. I'm Dean Reuter, Vice President, General Counsel, and Director of Practice Groups here at the Federalist Society. I am not Judge Ryan Nelson of the Ninth Circuit, but we're having some technical difficulties, trouble getting him linked into our Zoom call. So I am going to, at least at the outset, act as the moderator for this, our final panel of the day. I'm very pleased to welcome our three panelists. We're going to be talking about administrative law and regulation, regulatory practice and oversight in 2021 and beyond. And I'm very happy to welcome three guests who, in this audience, probably don't need much introduction, so I am going to be very brief. We're going to get opening remarks from each of about 5 to 8 minutes. We're going to hear first from Ron Cass. Ron is Dean Emeritus at Boston University School of Law. He's also president of Cass and Associates. He'll be followed by Adam White. Adam is the Assistant Professor of Law and the Director of the C. Boyden Gray Center for the Study of Administrative Law at the Antonin Scalia Law School, George Mason University, right here in the Washington area, and he's a resident scholar of the American Enterprise Institute. Finally, our good friend Sally Katzen will speak third. She's a professor of practice and distinguished scholar in resident and co-director of the Legislative and Regulatory Process Clinic at the New York University School of Law. With that, Ron Cass, the floor is yours.
Well, thank you. I'm going to start with a story that's obviously true. It involves talking animals, the sure sign of a true story. This story may only make sense to those of you who are old enough to remember telegrams. So a pig walks into a telegraph office and says he'd like to send a telegram. The fellow behind the counter says, that'll be $10 for 10 words. So the pig at that point says, I'd like to say oink, 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 oink. The fellow who's working the telegraph office says, that's only 8. You can have 2 more oinks if you'd like to add them. At which point the pig says, then it wouldn't make any sense at all. Obviously, there are settings where you have to know who you're talking to and what that person thinks like. When we talk about what might happen in 2021 beyond in a new administration, whether the administration turns out to be a Biden administration or a Trump administration at the end of the day, I think there are a few things that are pretty clear. One is that while the sort of orders that come from the president, the sort of executive orders about regulation, can make a difference. And some of the orders that came down in President Trump's last 4 years obviously did make a difference. What makes a lot more difference in how the executive branch operates and how the regulatory structures operate is who is in the offices, who is making the decisions, and what the policy instincts are of the administration. So if you look at the FCC's regulation of the internet under the Obama administration, the Trump administration, or you look at the EPA and the regulation of power generation, or the Labor Department's attitude toward overtime pay rules, or Homeland Security's approach to immigration. Obviously, you have enormous differences in the substance of policies, in the details of policies that are made by the people in charge and the priorities of the administration. In addition to the people in the executive branch making a huge difference, who is in Congress also makes a difference. You have oversight of the regulatory and executive agencies. The oversight that you get depends not just on the structures in Congress, but on who's in charge, who the people are, who actually has control of the oversight levers, whether those are people who are essentially sympathetic to what the administration is doing or people who are opposed to them. At the same time, the judiciary and the rules for judicial review matter. There, the people obviously can make a difference in some cases, but people make a lot less difference there than the precedents do. You have an enormous level of unanimity in the way that courts decide cases on judicial review. If you look at circuits like the DC Circuit, which are reported by academics to be circuits that only make decisions on the basis of the politics and the personal inclinations of the judges, the DC Circuit is unanimous something like 98% of the time. And yes, while there are some important cases where there is disagreement, there are some important cases where there's divergence among the judges, as there is in the Supreme Court, among the justices. The precedents have a lot more to do than the personal inclinations of the judges with the decisions you get. Over the last couple of terms, we've had decisions in some important cases from the Supreme Court, in the Kaiser case, in the Department of Commerce case, the census case, in the Homeland Security case dealing with the repeal of DACA. You have decisions from the court that not only have purchase in the individual decision, but that also open doors to different ways of making decisions over the coming years, so that the Kaiser case, which refuses to overturn the Auer decision, overturn the decision that gives special deference to agencies' readings of their own rules, while it refuses to overturn the decision, Kaiser essentially rewrites Auer. It does bring in some of the decisions of the Supreme Court that made some exceptions to Auer, but very largely it rewrites it, and rewrites it in ways that also suggest potential changes to Chevron, because it shows you that the court is looking at exactly what it was that Congress gave to the agency to do, exactly what the boundaries are of discretionary authority. In the Department of Commerce case, which dealt with the addition of a question to the census on citizenship, the court goes through the case and has a fairly generous way of looking at judicial review of agency decisions that are discretionary decisions. And then at the end of the case says, but we're going to look at whether this decision was a pretext, which means that you have to look at the motivations of the decision maker, something that courts have been quite resistant to going back to the Morgan cases of the late 1930s and early 1940s. In the case that deals with Homeland Security, you also have a change in how the court is looking at these cases that really does open up possibilities for the courts to be much more intrusive in their review of the executive decision. So I think that while the first 8 oinks are fairly clear, what the last 2 will be and whether they'll be added over the coming years depends a lot more in the executive arena on who's there, and in the judicial arena on how the courts interpret the recent decisions. And with that, let me turn it over to Adam White.
Thanks, Ron. Let me begin by saying a few words about administrative law, and then I'll finish with some broader themes on the administrative state. On administrative law, we're obviously in a very interesting period of flux, and I think to understand where we're going in the years ahead, we need to think clearly about where we've been. For about 4 decades, the animating force and energy in administrative law was largely conservative, exemplified by Justice Scalia, Chief Justice Rehnquist, and the reforms that they made to administrative law, beginning with cases like Vermont Yankee and then heading through into Chevron and Justice Scalia's longtime defense of Chevron. They were reacting to a few errors that they saw preceding them, right? Judicial micromanagement of federal agencies in the Nixon and Ford and then Reagan administration. Not enough room for presidential-led policymaking in administration under these practically open-ended statutes. Not enough, in that sense, not enough room for elections to have consequences. And so their reforms, which we inherited, Ron didn't inherit them, he was present for the creation, but I inherited them. Those reforms were aimed at specific evils that Scalia and others saw in the law. or not evils, but excess. And it was the same excess that the conservative legal movement in general was pushing against in terms of judicial micromanagement of policymaking through legislatures and so on. It was part and parcel of the basic movement of judicial restraint. And Chevron exemplified it. In Chevron, the court tried to strike a new balance between political accountability and expertise and the rule of law. And by striking a balance, of course, it meant that we weren't getting perfect versions of any of those three things. And so there were drawbacks, and they became evident over time. Scalia's famous defense of Chevron in his Duke Law Journal article conceded all of this. The challenge that Chevron would pose to the rule of law if Chevron weren't applied correctly as he saw it. The danger of just chaotic flip-flops from one administration to the next. And so the Chevron balance always had its critics, first from the left and now more recently from the right, especially on the issue of the rule of law. And that's where we are today. Obviously, Justice Thomas, Justice Gorsuch, and Professor Philip Hamburger and others have pointed out that modern administrative law, though largely created by conservative reformers, opens real questions about whether we have a real rule of law in administration and the administrative state. And so we've seen reforms pushed from conservatives and libertarians on Chevron, on our deference, on the non-delegation doctrine, which of course Scalia was wary of because he thought it could be standardless judicial lawmaking. But those who wanted to see a more energetic, assertive judiciary on these issues are calling for a stronger judicial hand on these matters. That's where most of our attention has been paid in the last few years, is the reforms that Justice Thomas and Gorsuch and others have called attention to. And they're important, but I think it's also important to pay attention to the other conservative reform effort that's kind of happening in plain sight. And I don't think it gets as much attention, in large part because it's being led by Chief Justice Roberts. In some of his opinions, he's been the court's most full-throated critic of the administrative state. You just go read his dissent in City of Arlington, one of the Chevron cases. But more often than not, he's been in the majority in some cases, some of which Ron mentioned, which have had a significant impact on the shape of administrative law going forward. He didn't write the majority in Kaiser, but he was clearly at the heart of it, along with Justice Kagan, in trying to recalibrate judicial deference, not get rid of it, but give more weight to some factors like expertise and steadiness of interpretation over time, rather than others. We saw Chief Justice Roberts write the single biggest limit on Chevron that we've seen in a generation, and that was in his King v. Burwell case. And then we've seen him at the forefront of cases on, as Ron pointed out, the DACA rollback case and the Commerce Census case, the Homeland Security DACA rollback case, where Chief Justice Roberts has led the court in saying that the agency might be free to change its mind on issues, but trying to push the agency to be steadier and more transparent and more explanatory in the way that it makes those changes. I'm actually much more amenable to those reforms in the law than I think Ron is. For me, I look at them and I see the court almost operating with a gravitational pull towards what the framers did sometimes refer to as steady administration. Right? We need energy in the executive, not for its own sake, but for the sake of steady administration. And that the old consensus of Chevron and other deference allowing for much more sort of agency back and forth over time, or flip-flops, there's some value in that, but you can have too much of a good thing. And I think Chief Justice Roberts has pointed out that administrative law or administration seems less and less law-like as we have these wild swings in policy from one administration to the next. And so the question is, how can administrative law smooth that out? We've seen some of that in the Trump administration, and now as we move into the Biden administration, it will be interesting to see how the DACA case, the census case, Kaiser, any reforms to Chevron, how that might affect a Biden administration's attempt to quickly or significantly change policy. Just a quick word on the administrative state when I'll close. Administrative law is part of this issue of the administrative state, but it's only one part of it. And I think we need to pan back from time to time the bigger picture about how our government actually is administered and how it administers laws. I think it was a little unfortunate that the Trump administration began on this point with Steve Bannon's famous or infamous line about deconstructing the administrative state. Of course, there were policies that the Obama administration left behind that needed to be deconstructed individually. I was in favor of many of those deconstructions. But overall, as far as the administrative state goes, the challenge is really reconstruction. It's one of how do you build institutions that actually embody the values that better comport with the Constitution, and have those institutions, and not just scattershot judicial opinions, actually preserve the values that ought to be preserved. There's been some interesting writing outside of the law on this, which I'd encourage people to read. Tyler Cowen, the economist at George Mason, wrote a fascinating article a few months ago about what he called state capacity libertarianism, sort of a strong state that can comport better with libertarian principles. There's a new book out by the journalists John Micklethwaite and Adrian Wooldridge of Bloomberg and The Economist, a book called The Wake-Up Call, calling for a conservative but more expert administrative state. I think it's worth reading those things, even if we don't agree with them. I think we ought to at all times be thinking about how to build institutions that can better take on the constitutional task of governance. And we need to remember at all times, Hamilton's line, so important, he said it twice in Federalist 68 and 76, that the true test of a government is its tendency and aptitude to produce a good administration. That's the test of government, as Hamilton saw it. And I think we ought to focus more and more on that test. And so what are the issues that thinking presents? There's a few that I think conservatives and libertarians especially need to think through in the years ahead. What's the role of expertise in administration, and how do you best balance it with political accountability? What's the role of civil service in administration? How do you ensure to have an expert civil service, but one that is kept in where that expertise is kept within its proper role? What's the role of Congress's power of the purse in administration? This is a place where there needs to be much more scholarship. It's a total blind spot or a lacuna in administrative law, Congress's power of the purse. But of course, in many ways, it's the most important part of all, most important issue. In all these things, again, I think the key question going forward is not deconstruction, but reconstruction, not how to tear down policies or doctrines that we don't like, but what we want to build in its place. And so on that note, let me turn it over to Sally Katzen.
Thank you, Adam. I am delighted to be here and to join my good friends on this panel to talk about a subject we all love and have spent a lot of time thinking about: administrative law and regulatory practice. We probably all need to get a life instead of spending time on this subject. I do agree with Ron that people is policy. And I sure hope Adam is right that the Chief Justice values and will promote steadiness on the court. But we have our differences that will surely emerge in the question and answer part of this panel. For now, I want to spend my few minutes in opening comments sketching out what I expect in 2021 and the next few years in this field. And I've organized my thoughts, as Ron did, along the three branches: Congress, the administration, and the courts. Congress. I believe there will be likely little activity or accomplishments in our field on Capitol Hill. Not only are there far more pressing issues from the pandemic, the economy, race relations, climate change, Senate confirmation of Biden's senior administration officials, just to name a few. But in addition, with the Republicans controlling the Senate and the Democrats controlling the House, there will be little, if any, new authorizing legislation. There'll be no reg reform legislation. And there'll be no use of the Congressional Review Act to set aside any Trump regulations. There will likely be more oversight of the agencies by the Senate, which can now move from inquiries, about Benghazi or Hunter Biden. And there'll probably be less oversight in the House, although Democrats are not so solicitous of their leaders in the White House as Republicans usually are. Now, with respect to the administration, I think we can expect an immediate uptick in regulatory activity. There are several buckets. Biden will immediately rescind the Trump regulatory executive orders, especially the 2-for-1 and regulatory budget experiments, and the creation of Schedule F that would strip civil service protections for many career civil servants. I think that's a given. Agencies will likely reverse the Trump regulations that rolled back the Obama regulations, especially those relating to climate change, healthcare, and worker protections, updating the Obama version where appropriate. Agencies will also likely expedite new regulations in those areas of particular and compelling concern to this administration, such as race relations, the pandemic, and criminal and environmental justice. I believe they will end the suspension of enforcement of the rules on the books. That is, rules have the force and effect of law, and this administration has gone to great lengths to end reporting, end inspections, waive penalties, etc., for non-compliance with those rules. That I suspect will change. And lastly, I think there'll be a serious reexamination of the rulemaking process, starting with Executive Order 12866 and focusing on everything from increasing access of marginalized communities in the rulemaking process to such technical issues as giving weight to non-quantifiable benefits and distributional equities. I'm uncertain about two other issues: whether the Biden administration would follow Trump's lead in asking the courts to hold in abeyance or suspend rules that have become effective but not yet taken effect because of judicial intervention, and whether they will use the interim final rules, which got an unexpected boost by Justice Thomas in the Little Sisters case, to put in place their regulatory preferences before notice and comment. Now, with the Supreme Court, I think we will see changes in administrative law coming from the court, some sooner rather than later, because it will take some time, at least a couple of years, for most of the Biden administration rulemakings to reach the high court. But over the last decade, I'm going to look back further or so, there's been increased skepticism, if not hostility, to the administrative state by the Supreme Court justices. And the recent addition of 3 new justices will, in my mind, likely accelerate that trend. I don't know how it will manifest itself, whether it will take the form of greater receptiveness for the non-delegation doctrine that was discussed, fewer protections for civil servants who staff the administrative state. We saw hints in Freetag, Peekaboo, and Lucia. Further restricting access to the courts itself by continuing to tighten the standards for standing, finality, exhaustion, ripeness. We've seen cases in all these areas that have limited judicial review. Whether there be greater scrutiny of the justifications for administrative actions, as Ron indicated in the Department of Commerce case. Imposing additional limits on deference to an agency's reading of its own authorizing statute or its own regulations. I don't see anything seismic. Most of the recent trends in these areas have been modest, dare I say timid steps, but I suspect that the march goes on and on and on. So I will stop, and I thank you very much.
I want to thank all the panelists for their opening remarks. I guess before we jump into questions, I'd ask if Professor Cass or Professor White would like to respond, or should we just jump into questions?
Well, I'm happy to just add a couple of thoughts here. And first, I have to say, with respect to Adam's comment that too much of a good thing is something we want to avoid. I'd be happy to have too much of a good thing. And on the comment that we have to find a place for expertise, I think expertise has often been something that has been leaned on to cover an unwillingness to engage with the fact that a lot of decisions that are made by experts, different experts will make very different ways. I think that a lot of the discretion that has devolved onto administrators is discretion that we articulate being there because of their expertise. But while there is expertise in a lot of things, that doesn't dominate a lot of what the administrative state does. With Sally, I think that certainly there are changes at the Supreme Court level. I see the changes at the Supreme Court level, though, very largely being in two camps. One is the camp that says we ought to divide sharply what is given to each branch. We ought to let Congress make the big decisions, write the laws, and then give to the agencies discretion to implement them and be clear about what discretion is being given. I see in the Supreme Court often an instinct to say, and I think this is true with different justices. I think it was true in Kaiser with the opinion written by Justice Kagan. I think it's true in a lot of other decisions that have a more conservative tilt, that the justices are saying, we ought to let agencies exercise their discretion. That's what Chevron was saying. We ought to let agencies exercise their discretion, but the courts ought to put the boundaries around that. The courts ought to interpret the law and say how far that discretion goes. And I think that the division in Brand X was a division between two different versions of how you express those limits, how you put borders around the exercise of discretion, but let the administrators exercise the discretion they have.
Can I nudge Sally on one of the points that she made? Sally, you said in describing what might come next in the Biden administration, rescission of the executive orders and on regulatory budgeting and so on. I kind of wonder why that's necessarily the case. I mean, maybe it will be, maybe that's just politics, but those orders were a very interesting experiment in rethinking how to do White House oversight of cost-benefit analysis. If anything, I think it would be nice if the new administration were to sit down and try to analyze what was the impact of those orders. Maybe it was terrible, maybe it was great, probably somewhere in the middle. But hopefully things like that and this administration's move on transparency in terms of guidance documents, whatever, I just hope that from the new Justice Department to the new OIRA to the new everything, I hope the Biden administration, the agencies will stop and try to analyze what just happened before if they just tear it all down because Trump's agencies did it. I mean, I just think that's not a very smart way to do regulation.
Well, I agree with you that the operating principle should not be tear it down because my predecessor did it. That was the guiding principle for the Trump administration, which if it had an O next to it, it was gone, and systematically reversing as much as they could whatever Obama had done. No, I think that there are some things. Take, for example, I'll give you one. When I talked about lack of enforcement of existing regs, there were a number of areas in which there was a relaxation in the healthcare area to enable telehealth processes during this pandemic. It had been against the rules to use telehealth. That was relaxed. That has been good. I am not saying that just because Trump did it, it will be gone. But the 2-for-1 in the regulatory budget, I think, has been studied a lot. And Adam, all of these studies have shown that you got 0 new regulations from the 2-for-1 and the regulatory budget in the areas of health, in the areas of environment, in the areas of protection of employees, in the areas of civil rights. I think we have a lot of data, and I think getting rid of those 2 executive orders is the product of study rather than knee-jerk. With respect to the creation, which is the other one I mentioned, of Schedule F, which deprives civil servants, thousands, potentially tens of thousands of civil servants of the protections they have had is a step far too far for almost anyone to want to take. And if you want people to implement anything, you need to have people who have something more job security than the Secretary of Defense, who found out by Twitter that he's no longer the Secretary of Defense. So I think that the ones I'm referring to are established by experience. Speaking of civil servants, and Ron, I hear what you're saying about expertise. It is not a blank check. It is not something which you can invoke to defend against any and all things. It does need to be cabined. I agree completely with that. But if you think that the Congress today or in the last half century would be able to provide the specificity, you can say you want clean air, but should the level necessary, requisite to protect public health, be it 7.0, 7.5, 8.0, there isn't a person in the Congress that has a background in those fields. We have a handful of doctors, we have a lot of businessmen and women, and we have a lot of lawyers and a lot of economists maybe, but we don't have plasma physicists, and we don't have any of the scientific expertise in the Congress to make those decisions. So I think there is a place for expertise. And yes, you can disagree as to whether it's 7.0, 7.5, or 8.0. But the beauty for me of the administrative process is that the agency has to spell out why it picked the number it did, based on which studies, why it ignored other studies, what the comments were, and how they treated them. And therefore, the expertise is not uncabined or unrestrained, and it needs to be explained. And if it is, we can still disagree. We're disagreeing right now, apparently, on the outcome of the election, but at least we have some common data that we can work with. And I think that's the role of expertise in the administrative state.
Okay, well, let me open it up with a question. Professor Cass and Professor Katzen, you both mentioned that people tend to drive the policies. This transition is unusual, it seems. In potential President Biden's camp, he has a transition team, but they don't exactly know what they're dealing with. They don't know who's going to control the Senate at this stage. And Professor Katzen, having been on the transition team for President Obama and Vice President Biden, I'd be interested in any thoughts you could share on, are they kind of setting up, do you think they're setting up two slates for if they win the two Georgia seats, or if they lose one of those seats, so they know whether they have to, what they're dealing with in Congress to get their cabinet picks through? Or are they kind of at this point just taking the assumption that they're going to have to clear anything through a Republican Senate and proceeding on that route as they choose these initial picks?
Well, I think that's a very good question, and I do not have an answer. I'm not in the transition and therefore can't speak for what they are thinking or what they would be doing. But I can speak to where President-elect Biden is coming from, and that's working with other people. And I do not see him coming up with two different slates depending on whether they have the majority or not of the Senate. I see him thinking, who is the best person for this job, who will bring to it the expertise, the experience, the gravitas, the sensibility, and the skills necessary to navigate in Washington. And that will be his choice. He will then obviously have to sell some rather than others. But he has run this campaign, and I thought his speech Saturday night was very powerful in saying there's one America. And I think based on that, there'll be one slate of his cabinet that he will put together that will reflect the diversity of opinion in this country, that will reflect the different views that people hold. I don't think he will shut his ears to any group or constituency. I think he's a listener, and he's very good at it, I think.
Professor Cass, did you want to weigh in?
Yeah, I wanted to disagree with one thing that Sally had said and agree with another. And neither one of those will surprise Sally. First, the side comment that the Trump administration just rejected anything that President Obama's administration done. I think that is not correct, and I think it is much less correct with respect to what happened the last 4 years than what's being teed up on the other side right now. Certainly, there were reasons to be concerned about the immigration initiatives that seem not to have gone through Congress the way a lot of people thought they should. There were reasons to be concerned about initiatives in the EPA's domain that seemed to have enormous impacts on the nation, probably not within what was contemplated by those writing the underlying laws. Certainly, the EPA, when it looked at some of the fruits of its actions at other times, said, well, we're going to have to rewrite the law to get where we want to go because we think this simply pushes things too far in that direction. So I would disagree with that characterization. I think that your comment about the good thing about the current process, the current administrative process, is both that there's a lot of expertise on technical things in the agencies and that the courts forced agencies to justify what they've done. I agree that there is a lot of expertise in the agencies, although frequently the agencies claim a scope of authority that goes beyond real expertise. It goes into personal judgments and political judgments. And there's a scope for that as well. There's a scope for that when Congress says, you have discretion over things. We're going to let you make up your mind. We're going to let different administrations come up with different solutions. Right now, I think some of the recent decisions from the Supreme Court give courts more options for picking and choosing when and how they want to conduct their oversight of what the agencies are doing. And I would like to see more clarity from the courts, more narrowing of the judicial discretion on that side, as well as more clarity on what the scope is of administrative discretion.
Okay, one more question. Professor Katzen also mentioned the Congressional Review Act, and I think aptly noted that it's unlikely to be used given that it looks like the Senate will be in Republican hands, or at least evenly divided, and might make it difficult. Interestingly, though, President Trump, the Congressional Review Act's been used 17 times in its history since it's been adopted. 16 of those 17 times it was used in the Trump administration, and to disapprove a rule. And when those rules are disapproved, the agency can no longer act on any rule that is substantially related to a disapproved rule without subsequent congressional action, which also seems unlikely. Are there rules that were disapproved at the beginning of the Trump administration through the Congressional Review Act that will put subject matter restrictions on any of the agencies for a Biden administration to act upon, if you're aware of any? Or are we going to see some litigation on the definition of substantially related?
Are you asking me? I having been one of the people who worked on CRA as the point person for President Clinton at the time, the substantially similar has never been defined, or at least not defined authoritatively. Does it mean virtually the same with modest changes that would hardly be noticed by a passerby, or does it mean in the same ballpark? If it's closer to the latter, there are a few things that were disapproved early in the Trump administration that they may attempt to think about. For example, I'm thinking of the Social Security Administration rule that would refer those who have disability because of mental health issues and cannot work because they are having mental issues, sending those names to the people who clear for permission to have guns registered in their names. That was a hot ticket item at the time. I don't think they're going to try to relitigate that one with or without further clarification. On the other hand, I think the first one that was passed was talking about, in effect, bribes to foreign countries. And that was something that took almost everyone, including Republicans on the Hill, some surprise. So of the 16, they're all different grades. In a way, I think it's almost too ancient to consider. There are really pressing problems now. And I suspect the agencies want to focus not on the past, but on going forward with the economy, with the pandemic, with climate change, with race relations, with criminal justice generally, that will take their attention and not try to revisit, and some might say rectify, others might say we'll just do over things that had happened in the past.
Professor Cass, I don't know if you had anything, or Professor White, if you had anything to add to that.
No,
Go ahead, Ron.
I think Sally correctly says that most of these things are not likely to be brought back up. And if they are, they're likely to be in a substantially different form. I think that people will, in any new administration, comes in, it looks at things with different people and different priorities, and that almost inevitably will give a different shape to things. I think it is unlikely that we'll see a lot of litigation over what substantially similar means.
I was just going to note the irony. Nobody really knows what substantially similar means. I remember 4 years ago when the CRA was being used, writing an essay with Sam Batkins trying to figure out what this means, and we just finally gave up on it. Really couldn't find the meaning either. Agencies are now going to be grappling with that sort of totally open-ended restriction on the agency's own freedom of movement, which is probably how a lot of the public feels when they face open-ended delegations of power to agencies to regulate them. And so I can sort of note the delicious irony of this, but I think it's sort of telling, right, that Congress decided, rather than actually tuning up actual delegations of power to agencies, they sort of used the delegation to be the delegation. And now we're all going to have to sit around in limbo and try to figure out what it means, because I think it's inevitable at some point an agency is going to touch on a subject matter that was struck down in a previous CRA rulemaking, and we're all going to have to sit around and figure out what this statute means. I guess it's a nice way to deter individual rulemakings that go overboard, but it hardly seems a way to run a country.
All right, well, we'll turn it over to some audience questions. And before doing so, I did want to provide the CLE password for those who are attending in part for CLE, and that is ADL19. And with that, we will go ahead and look at, see if there's any questions from the audience. If not, I can throw out another while while we're waiting. Let me. Sally talked a little bit about what President-elect Biden his priorities may be on day one. What other than the two executive orders that were mentioned, Professor Katz, and maybe it'd be good to have Professor White and Professor Katz weigh in as well. Are there other policies or other executive orders that a President-elect Biden may look to adopt in his first 10 days?
I thank you very much for that question. I think there are many, or at least several. I was focusing on those having to do with the administrative state. When I was choosing my examples, a third I did not. There are two other areas. There's an executive order on enforcement and an executive order on guidance, both of which I believe would warrant careful scrutiny. I'm not saying throw them out in their entirety, but I'm not saying embrace them. There were a whole group of those, but that bundle goes to process issues. And that's what I was addressing. I believe that you will see some executive orders in substantive areas. And he will resurrect, if you will, some of the general principles, whether it be for contractors or for enforcement of immigration, or in the climate area generally. In healthcare, a number of steps were taken by President Trump to limit or undermine, or whatever verb you choose to use, Obamacare. I think a lot of those will be reversed. Those were done by executive order, and I think you'll see changes there. So while I was addressing the process side, I think there's also the substantive side that they will pay a lot of attention to. There's been a lot of pent-up enthusiasm or dread, depending on what we're talking about. I don't have the answers, and I'm not sure anyone does. There's 70 some days before the oath of office is administered. And I know that during the transition that I worked on, the Obama-Biden transition, we got a lot jammed into those several months before turning it over, with the enormous help and cooperation of the outgoing administration. George W. Bush had said, in words of one syllable, I want this to be the best transition ever. You open those doors. You welcome the people. Meetings with Josh Bolton and others, where they said, you tell us what you want, you tell us what you need, you will get it. And he was true to his word. It was absolutely beyond impressive how George W. Bush handled that transition. So we had a lot of help. We were able to talk to civil servants and Bush appointees who, I remember I was doing, among other things, OMB. We were all over the budget, which has to go up within a very short period of time after the taking of the oath of office. And they gave us not only the bottom line, but also all of the backup material. Here's how we got to these numbers. So we could understand every single line item. They were magnificent, and we got a lot done. Will that happen this time? I leave that for you all to decide.
Right, Sally, I liked your approach to the process orders. I think we're going to call it distrust but verify. But I think that's a step in the right direction. One thing I did like that the Trump administration did, which would be interesting to see the Biden administration repeat, because I think they will, is the Trump administration's use of substantive executive orders announcing certain policies that they wanted their agencies on issues of financial regulation, labor regulation, energy and the environment. Just charting out general principles they want the agencies to pursue to the maximum extent allowed by statute. I think that's really great, and I've written about this for the Notre Dame Law Review. I think it's really great to see a president announce his policies, put his name on the line so that accountability for those policies can go all the way up and not stop at just an EPA administrator or the CFPB director or whoever. But it really shows that the president has put his capital into this. I think that's important to signal to the public where the policy is coming from. And I think it's important to signal down to the people administering, not just the cabinet secretaries, but the whole agency, that this is a core priority. And I really hope that President-elect Biden repeats that, and I hope it becomes institutionalized.
Well, the other thing that does, Adam, and I agree with you on that, is it also gives people more information about what's going to be happening with the laws. It gives more lead time for people to adjust and more clarity about how laws will be administered and interpreted. And on the same plane, I think paying attention to the nature of guidance documents that come out of the agencies, how they're prepared, which ones are done just by issuing a document without going through a rulemaking, what the nature of the rulemakings will be, how those are, I think all of that is very important going forward. I should say, Sally, that when you said these are things that need careful scrutiny, I never have heard anyone take the other side of that and say they need careless scrutiny. But when we get to that debate, I want to make sure I jump in with you.
Okay, we've got a couple of hands raised. Just to remind everyone, you won't be able to ask questions directly. You have to raise your hand and get called on. We had somebody who was on, but I'll move on to Jeffrey Wood. If you want to go ahead and ask your question. You'll have to unmute yourself.
Okay, can you hear me now?
Yes.
Great, thanks very much. Intrigued by some of Professor Katzen's remarks, particularly about the Schedule F regulations. I'm not sure exactly what the perceived harm associated with it is. I suppose I could speculate that, if it's viewed as a mechanism for removing federal employees who, for malign political reasons and motives, I can understand that might be a perceived harm. If it's conversely viewed as a mechanism for efficiency and making the federal workforce more responsive, more similar to the private sector, I would think that would be a good thing. And in part, I'm intrigued because if I were, say, theoretically a federal employee myself, otherwise protected by civil service protections, and imagine that I might be let's say, a supporter of President Trump. I know that's unlikely on a Federalist call, but I wonder perhaps if it might actually work to the disadvantage of the Biden administration to remove such a provision, depending upon the exact perceived evil or purpose of it.
Well, I appreciate your question, and let me try to answer it in a couple of different ways. First of all, it's directed at anyone having any policy input. It's not the clerks. It's the people who have contributed to policy discussions. And we saw when the landing teams, I could not believe they called them landing teams of the Trump transition, as though they were entering a foreign country with armed forces waiting on water's edge. But when the landing teams got to a number of different departments and agencies, they wanted names. I want the name of every single person who worked on climate change at the Department of Energy. I want the name of every single person who worked on healthcare at HHS. Many of those were civil servants who were doing their job being to serve the administration that is in authority at the time. Now, I was at OMB during the Clinton administration, and I saw firsthand that until 11:59 on January 20th, every single person was working their hearts out and doing the best they could to satisfy the office of the president. And at 12:01, they were working their hearts out and could do everything they could to serve the office of the president. And in those 2 minutes, the person who occupied the office of the president changed. It changed from Bill Clinton to George Bush. And they fulfilled their commitment. That's what you want in a civil service. You don't want the days of Andrew Jackson. You don't want where there's wholesale elimination. Now, you raised a very legitimate concern that I would never dismiss, and that is there sufficient efficiency in the civil service? Is there a way of disciplining or firing people who are not doing their job, not in terms of their political outlook, but in terms of their showing up on time, producing work within expected due dates, etc. And that is something which does produce some bad apples. But the system, when we're talking about millions of people in the civil service who are good apples, and they are doing what they have been asked to do and told to do, and for them to be held up by fear of retribution. And I will tell you, as having lots of friends in the administration, I'm not going to call it deep state, but they are in the agencies. They have been in the agencies in some instances for 5 years, 15 years, 25 years, 35 years. They're scared. They reacted to that executive order more forcefully, more angrily, but more terrified than anything that has happened in the last 4 years. So they perceive it as a terrible, terrible threat. And I don't think anyone in the private sector or in the public sector works well with the threat of a guillotine hanging over their neck. And so there may well be a loss of efficiency, and I hear you on that. And I struggled with that in my own time in government. But if you do a cost-benefit analysis, and I struggled with a lot of that as well, the benefits of civil service protection so far, in my mind, outweigh the costs that I'd go with it in a nanosecond.
I have a somewhat different perspective on this. And I speak as someone whose father was a civil servant for 30 years, despite occupying a position that throughout government is a politically appointed position. I know that civil servants, that there are plenty of civil servants who are dedicated to whatever people they are serving, whoever is in office at the time. And there are plenty of civil servants who also work tirelessly and efficiently. But I don't want to overstate, and I don't think we do anyone any good overselling the reaction people have based on rumor and press reports. And I also think that in many agencies, agencies differ. In some agencies, you have a real diversity of people within the civil service. In other agencies, you have people who got to the agency because of a deep-seated belief about what they wanted the mission of the agency to be. Maybe it was the mission at the time, but certainly it was a mission those people embraced. And if somebody came in with a different view, with a different policy set of preferences and priorities, there was not uniformity in how people would respond to that and how many civil servants would embrace that. Certainly, when you look at the arguments that rise to the surface in the census case, you see a real divide between people who are in agencies long-term and have their own policy preferences, and people who come in with a change in administration and want to implement new policy preferences. It's not always something that happens without any sand in or grinding of the gears. So I'm sympathetic to the notion that some changes need to be made and that more opportunities to get responses to whoever's in office who is running the policy position, who is exercising the delegated discretion to get them to be able to accomplish what they see as the mission for the agency while they're there.
All right, we'll move on to the next question. And again, just wanted to remind those who need the CLE code that it is ADL19. And now we will move on to Randolph J. Go ahead and remember to unmute your mic, and they will let you speak.
Thank you, Judge. This is Randy May, my middle initials, J, Randolph J. Thanks very much, and hello, all of my friends there. So I want to the video's not on, is it? Because I would have gotten dressed up, but I don't think it's on. I want to go back to the non-delegation doctrine for just a second. And, you know, I've been an advocate of some type of revivification of the non-delegation doctrine, if that's a word, or breathing new life into it. So my question is this. Of course, we now have the intelligible principle standard that, you know, was enunciated in 1928. And I understand it hasn't, you know, the two cases in 1935 were the last ones where the non-delegation doctrine, as it's, you know, properly understood, has been invoked. And, you know, I know what Justice Gorsuch said and Gundy, familiar with all of that. But I've always thought, you know, I think he basically said it ought to be jettisoned. But here's my question to, I guess it's maybe more to Ron and Adam, but Sally can chime in. I want you guys to help me out. How, if you wanted to breathe more life into it, I've always thought there would be a way to just reformulate the intelligible principle standard and have, you know, intelligible principle plus that would say perhaps something like, you know, the statute must have an intelligible principle that may be measured by reasonably objective criteria that relate to a legitimate legislative purpose, or something that would add. So can help me out can you envision something that's just a little more than what was said in J.W. Hampton that would be workable, or is it like Scalia thought, just not workable to do anything else?
Well, Randy, I'm happy to take a first crack at this. First of all, there's a picture of you on my screen wearing a coat and tie, so you look terrific.
God, I was afraid you were going to say something else, so thanks for that.
As to the intelligible principle test, when Chief Justice Taft wrote that opinion, he took a different tack from the other Chief Justice who wrote a notable opinion on the delegation doctrine, and that's John Marshall. John Marshall thought all the important decisions should be made by Congress, and then things that were less important, you could let somebody else make. And part of what Chief Justice Taft said is that there are decisions simply too important to be left to anyone but the chief executive or people working for him. So it was a completely different way of looking at things. The intelligible principle doctrine, I think, is just the wrong doctrine. I think the question isn't whether you have an intelligible principle, but what the actual decision is that's being left to somebody in the executive branch or in the courts. If it's something that, back in the first or second Congress, I think it was, they passed the Residence Act, which set up the District of Columbia. And the tough political decision was exactly where the capital of the nation would be. It was a hotly contested issue. It was one that divided people around the country. Congress made that call. They said, pretty much exactly where it was going to be. And then they left the very fine details of buying or getting or having states cede the land to a commission. They left to the commission setting up all the government buildings, and they didn't even give any principle for how many buildings of what type, where they'd be. I think that's the sort of thing you don't need any sort of intelligible principle. It's just not important enough to be worried about the commission exercising that authority. I think John Marshall had it right when he said it's the nature of the authority you're giving out rather than the detail with which you assign it to people that we ought to be looking at. And I think it's hard to get a really clear judicial test for that. That's why Justice Scalia was an opponent of a vigorous non-delegation doctrine. It's the one thing he and I argued about for decades without coming to agreement on. I'm not going to tell you who capitulated on most of the other things, but I do think that we would be better off trying to find a better way of cabining delegations than the intelligible principles.
I could just say a word. The last big non-delegation opinions obviously were in the Gundy case. And they came out right within a couple of weeks, if I remember correctly, of the political gerrymandering case, where the Supreme Court said there's just no standard here that's capable, a judicially enforceable standard capable of dividing unconstitutionally political gerrymanders from constitutionally political gerrymanders. And when that happened, I wrote a short note on one of the law blogs saying conservative reformers of the non-delegation doctrine ought to focus more on the gerrymandering opinions than the Gundy opinions to really see the challenge of constructing a judicially manageable non-delegation standard. And so I'm hopeful that we'll find a new standard. And these recent opinions, Gundy and Justice Kavanaugh's opinion and Paul, they're the opinions that have launched 1,000 law review articles. But we'll see. Like Ron, I wonder if maybe ultimately the energy will be channeled into sort of auxiliary precautions, so to speak. Maybe we just do need judges to use canons of construction to narrow fields of discretion in order to avoid the constitutional problem. Maybe we need courts to do more work of what James Madison called liquidation, right? Over time, help fix the meaning of a statute in one place so that then the political energy isn't channeled into a new administration flip-flopping from one to the next, which, by the way, exacerbates all the civil service issues that we were talking about, but channels the power into the legislative process. I know maybe Sally's going to say, what legislative process? It's all broken. Congress doesn't do anything. And that's true. I think that's as much a symptom of the delegation issue as a cause. I think that it's because the agencies can more or less venture whatever gambit they want to, that you don't see as much political pressure on Congress to really compromise. They know that the pressure release valve is the agency process anyway. And so I would like to see more effort focused on the major questions doctrine and on this issue of liquidation.
The only thing I would throw into this discussion is for those of you who want to read about it, is Nick Bagley and Mortenson's article where they look back at the very first several Congresses to see if there was any delegation and what kind of delegations exist. And Ron talked about one, patents is another area, tariffs and trades is another area. where they found an enormous amount of delegation by the founding fathers, which cast in doubt some of the theses on which those who want to change the non-delegation doctrine have pursued. I actually like Adam's suggestion about where energy should be spent, so I don't want to detract from that. Thank you, Adam.
Sally, I feel so bad because I was going to kind of dump on what you just said.
Don't do that.
After they read Bagley and Mortensen, be sure to read the new article. It's out by Philip Hamburger. He has the latest piece on what he calls the issue of divestment. And it really is a direct response to Bagley and Mortensen. Our cup runneth over in things to read on non-delegation.
I was going to say we could spend a lot of time doing a lot of reading, and if the pandemic continues, we may do just that.
I think Elin Werman has another piece responding to that as well. There are several more pieces coming out from other people. So I would say, Adam, I agree that looking at particular canons of construction is helpful. We just have to make sure it's with 2 ends and not 3.
All right, I think we've got time for one more question, and I'll go ahead and take the prerogative. Regarding the appointments clause, last term the Supreme Court weighed in and said that the CFPB had to go through through advice and consent. They've taken another case with the Federal Financial Housing Authority, and then they just granted certiorari in yet another case addressing the appointments clause. Why has the appointments clause become such a hot topic? And is this something that is temporary for the Supreme Court to get some guidance, or is this a longer term structural concern that is being addressed?
Well, if no one else wants to address it, I think that there are 2 things that drive this. First of all, there's been a lot more concern across the board with structural issues that have to do with the delegation of large amounts of authority to administrative entities. And that's why there's a lot of writing about non-delegation. That's why there's a lot of writing about the degree of deference given under Chevron or under other doctrines. But also, there have been more statutes that have been passed that really do cabin any sort of oversight, whether it's executive or legislative. You know, if you have an agency, I think Sally may have mentioned the power of the purse, but certainly if you have an agency that's insulated against congressional oversight in terms of regulating its budget, you have an agency that's insulated against executive oversight in terms of how it adopts policy. The more you pull back the agency from the usual controls, the more concerns over doctrines that may cabin agencies' authority and regulate agencies' use of their discretion become important and become talked about.
Okay, well, thank you all. And I think we're kind of hitting at the end here. So we'll go ahead and really want to just thank the panelists for a robust discussion and kind of a bit of a crossroads for administrative law and probably for many areas generally. And thank the audience for joining us today. I want to remind everyone that the next convention event, a discussion of rule of law or just making it up, First Amendment tiered scrutiny, will begin at 11 a.m. tomorrow morning. And with that, we'll go ahead and let everyone have a good evening. Thanks again.
Thank you.